This video on establishing the first court order for legal decision-making, parenting time, and paternity in Maricopa County is presented by the Law Library Resource Center, which is part of the Superior Court of Arizona in Maricopa County. Links to forms, packets, and other resources are available in the video description below. The first thing we're going to look at is a flowchart, which shows the basic steps of the process we're reviewing today. It's available in our step-by-step guide and was included in your confirmation email. It's a great resource, and you might find it useful during the presentation. Our forms are grouped into packets and steps. Packets include instructions, procedures, and forms for that step of the process. Each major step is a packet of forms and instructions. You generally need every form in a packet except for the service packet. This is the packet for starting a case to establish your first court order for legal decision-making and parenting time when paternity has already been established. This is the packet to establish paternity along with legal decision-making, parenting time, and child support. This is used when the father's name is not on the birth certificate for one or more of the children involved. And here's what we will cover today. The requirements to file the processes we'll be discussing. The process from initial filings to the final orders or judgment. What forms are involved and what they mean. When to file to establish paternity. What legal decision-making is and how it's decided. What parenting time is and how it is decided. And how child support is determined. The requirements to file in our court are: you must be a parent of all the children involved. The children have lived in Arizona for at least the past 6 months, or from birth if younger than 6 months. And no order exists for legal decision-making or custody in any state. It's important to know that you cannot use these forms if you are married to the other parent. If you are married to the other parent, you will have to file for divorce or legal separation to get orders for legal decision-making and parenting time. If there is already an order for child support in Maricopa County, you can file to establish legal decision-making and parenting time. However, you'll need to use the same case number and party designations. So, when should you use the packet to establish paternity? You must file to establish paternity when there is no father listed on the birth certificate for one or more of the children. When more than one child is involved, it's okay if the father's name is on some, but not all of the birth certificates. Also, you can use one packet or case when you believe you or the other party is the father of all the children involved. And if there are multiple fathers, you must file a separate case for each. If there is a different father's name on the birth certificate, you cannot use our packet to establish paternity. This means you can't use these forms to remove a name and add a new person as the father. We do not have a packet for this situation, and we recommend you talk to an attorney for help. Now we're going to talk about the process. The first step, which we call Step 1, is where one party files the first papers to start the case. Usually this person is called the petitioner or Party A. The second step is for the petitioner to arrange to have the papers served on the other party. We call the other party the respondent or Party B. Step 3 depends on the other party and whether they file a response. If the other party wants to disagree, they have a limited amount of time to file a response. The response tells the court and the petitioner what they disagree with and what they want the court to order instead. It's not necessary to file a response unless the other party wants to disagree. It costs money to file a response, and there is no need to respond or pay the response fee as long as the parties agree on everything. If the respondent does not file a response, the petitioner can go on to Step 3, which is called default. When no response is filed, in order to move the case forward, the petitioner must file Step 3, default. This is the default packet and includes the application for default. It tells the court that the other party was properly served, that their time to respond has expired, and that they did not file a response. The court then assumes the parties agree, which allows the case to move forward. After the waiting period, the petitioner can move to Step 4, the default judgment or order. When a response is filed, the court will schedule a resolution conference. This is the first step in trying to reach a settlement or agreement. The court will issue a document called a minute entry with instructions and reminders about things to do before the resolution conference. If all settlement attempts are not successful, the court will set a trial date for unresolved issues. If the case goes to trial, a judge decides and makes orders. Step 4 includes a judgment or order for use after trial. There is also a consent judgment if the parties reach a full agreement, and parties can sign a consent judgment at any time. If the respondent has not filed a response, they must pay a response or appearance fee before a consent or agreement can be submitted. Let's look at the flowchart again. It shows the basic steps of the process to establish legal decision-making, parenting time, and child support, with or without paternity. You can see the steps to proceed by default, which is when the other party was served and did not file a response. You can also see the steps for a trial, which can happen when the other party was served notice and did file a response. Finally, there is the consent judgment or order when the parties are able to reach a full and complete agreement on all issues. You may find this chart helpful to refer to whatever path your case takes. And just a reminder, it's available in the packets that were provided and on our website. Okay, here's some important information on filling out court forms. When printing and saving court forms, all documents must be one-sided. This is because they're scanned and saved electronically, and anything on the back will not be scanned or filed with the court. All our forms are fillable PDF files, and they can be typed. Well, they don't require it. Judges prefer typed forms, and it's highly recommended that you type your responses. But if you do handwrite them, your writing must be printed and legible. No cursive writing. Also, you can only use black ink. And one more thing about filling out forms. Do not leave blanks. If something doesn't apply to your situation, just cross it out. Write NA for not applicable, or put unknown. When you file your first papers, the filing fee is due. The most current fees are on your screen. However, they are subject to change. Please check the Clerk of Court website for the most recent information. Payment is due at the time of filing the petition or response. The court accepts payment by cash, credit card, or money order. If paying the full amount at the time of filing is a problem, you can submit a fee deferral application to ask to waive or defer the fee. A waiver means the fees will not be owed at all. This is granted only in limited circumstances. Deferral means you'll have a payment plan or possibly get a bill later. Most people qualify for some kind of payment plan. If you are granted a deferral or payment plan, no interest is charged. But a one-time payment fee of $35 will be added to the total amount paid to the court. The following is a list of forms that are required to start a case. The Sensitive Data Cover Sheet provides information to the Clerk of Superior Court. The summons tells someone they are being sued for paternity and/or legal decision-making. The preliminary injunction is an immediate court order that applies to both parties. The petition tells the court and the other party what you're asking for. And the parenting plan tells the court and the other party what you want to do about legal decision-making and parenting time. The order and notice regarding the Parenting Information Program has information about the parenting class required by the state of Arizona. And the child support worksheet shows the amount of child support as determined by Arizona guidelines. Now we're going to go over what's called the Family Department Sensitive Data Cover Sheet. This document is confidential and not available to the public. It's not served on the other party. It's only information for the court. And here's a very important tip. For each of these forms, you must always complete the case caption. The case caption is where you record the information about the person filing. It's located in the upper left-hand corner of the first page on each form. The case caption must include your name and address, unless you've asked to have it protected by the court, and your phone number. You'll also need to include your email address if you want to be contacted that way. And if you're representing yourself without a lawyer, make sure you check this first box. The case caption also includes the party designations. Enter the name of the petitioner, or Party A, and the name of the respondent, or Party B. These designations will never change. If you are the petitioner, you'll always be the petitioner, even if the other party later files to modify the orders. Unless you already have a case number from a child support case, the clerk will assign a new number when you file to start the case. And an ALS number is related to child support. Enter it if you have it, otherwise you can leave it blank. And here we have the summons. The summons is a notice to the respondent that they're a party in a court case. It tells them what happens if they take no action, and it explains how long they have to take action. We'll talk more about the summons in a little bit. The preliminary injunction is an immediate order to both parties once the respondent is served. It tells parties with children that they cannot travel out of state without permission from the judge or the other party. And it also says that a party can't remove the other party or kids from health plans. It's an order that can be enforced and is effective until the court makes the final orders. If you want these preliminary orders to be enforceable, you must attach a copy of one of the following: a birth certificate, an affidavit of acknowledgement of paternity that is signed by both parties, an order of adoption, or a court order establishing paternity, which may include a child support order. And this is the petition. The petition is the main form that provides information to the judge and the other party. It also tells the judge and other party what you want regarding legal decision-making, parenting time, and child support. If applicable, it asks the court to name someone as the legal father and whether to order the Office of Vital Records to add his name to the child's birth certificate. You can also ask the court to change the name of the child. Certain questions on the petition must be true and marked as true for your case to proceed. If you fail to mark boxes that certain things are true, you risk getting to the end of your case and having to start over. The court could require you to go back and file an amended petition and then serve the amended petition and otherwise repeat the process. Or the judge would have your case dismissed, which would require you to start over and pay another filing fee. These are some of the statements that must be true and marked as true. Venue is about which county you're filing in. Checking this box tells the court that this is the proper county for the papers to be filed in. Maricopa County must be the county of residence of either party or the children to file in our court. Jurisdiction means that this is the proper state and court to file the papers. You must be able to check at least one of these boxes to tell the court why it has authority to make decisions concerning the other party. Check as many as are true. Legal decision-making is about who makes the major decisions in the child's life. It includes where they go to school, what religion they're trained in, major medical decisions, and personal care decisions. It's based on the best interest of the child and considers many factors which are listed in the statute shown on your screen. Joint legal decision-making means both parents share the responsibility of making important decisions for their child. Neither parent has more power than the other, unless the court or the parent's final agreement specifically says so. If joint decision-making is ordered, both parents must actually make decisions together. It's not enough to just inform or check in with the other parent. Arizona law favors joint legal decision-making unless there has been significant domestic violence or one of the parents has a drug or DUI conviction in the past year. Sole legal decision-making does not mean one party has parenting time and the other does not, and joint legal decision-making does not mean 50-50 parenting time. One party can have sole legal decision-making, while both parties share parenting time equally. Parenting time is also about where the children will live and when. The law requires reasonable parenting time that is substantial, frequent, meaningful, and continuing contact. Exceptions are made if the court finds after a hearing that parenting time would endanger the child's physical, mental, moral, or emotional health. If you believe reasonable, unrestricted parenting time would endanger the child, you may ask that the other parent's time with the child be supervised or restricted. And in an extreme situation, you can ask for no parenting time at all. If you do ask to impose conditions on the other parent's time or for no parenting time at all, you'll have to provide an explanation why this is in the best interest of the child. The parenting plan is where you tell the court what orders you want for legal decision-making and parenting time. This includes time for the school year, holidays, vacations, phone and email contacts, and other restrictions or limitations. When you submit this with the petition, it only requires the signature of the person filing, even if you believe the other party agrees. If both parties agree on all terms of the parenting plan, space is provided for the other party to sign. And if you're submitting a parenting plan with a consent judgment or order, both parents must sign it. One thing you should know, the court may require a more detailed order regarding schools and education. If the court orders parties to complete an education order, these are available on our website. They're under the Other Forms section of the Family Court Forms page. Now we're going to discuss the PIT class. Arizona requires parents involved in a family court case to complete the Parent Information Program, also called the PIT class. It's a roughly 4-hour program on how to work with the other parent in the best interest of the children. There is a fee for the class, but the cost depends on the class provider. You can also apply for a fee deferral or waiver. The classes are in English and Spanish and may be available in other languages. They're available online and in person, and once completed, the course provider will transmit the certificate of completion directly to the court. The PIMP order and notice orders both parents to take the class and lists contact information for the class providers. All pages, not just the front page of the notice, must be filed and served on the other party. A parent who does not file a response or complete the class may still be granted parenting time. However, the court will not consider a future request from that parent to change or enforce the order until they complete the class. If either parent finished the class for another family court case, they may not have to retake it. They can submit a motion to ask a court to accept the other class. It's also important to know that if you're attending the program in person, the parents are not allowed to attend together. All right, now we'll go over how to file. Once you've filled out all the forms, you'll need to make copies and file them with the court. You can file in person, or you can file online using eFile. We'll go over eFiling in a moment. If you're filing in person, make 2 copies of everything except the cover sheet. The original is for the court. 1 copy is for you, and 1 copy is for the other party. If the Division of Child Support Services is involved in your child support case, you'll also need to make an extra copy for them. Next, file all the documents, including the cover sheet, with the Clerk of Superior Court. There are 4 clerk locations where you can file. 1 in downtown Phoenix, 1 in North Phoenix, 1 in Surprise, and 1 in Mesa. The clerk will keep the originals and return all the copies to you. Also, it's important to note that you must pay the full fee or turn in the fee deferral application when you file. You can apply for a fee deferral or waiver online or in person. If you decide to e-file your forms, please read the e-filing instructions first. There's an additional processing fee for each document that's charged by the e-filing provider, not by the court. You can pay the fee online or complete the online fee deferral application first. Also, the e-filing program creates many of the documents in the first step, so you don't need to complete the paper versions of those forms. Once the documents are submitted and accepted, you'll need to print at least one of each document. You can only serve paper copies of the forms on the other party. So once you've filed your forms, the next step is to arrange to have them served on the other party. Information and forms for this part are in our Step 2 service packet. There are a few different ways to properly serve the other party. The acceptance of service method is generally the cheapest, and if you work well together, this might be the best option. You'll need to mail or simply hand a copy of the papers and an acceptance of service form to the other party. They must sign it in front of a court clerk or notary. Then you have to make sure that the form is filed with the court. Service is not effective until the acceptance form is filed. We recommend that you fill out the form for the other party, except for the signature, to be sure all the needed boxes are checked. Signature confirmation is the next cheapest method. You can use the United States Postal Service or any national delivery service like UPS or FedEx, but it must be sent with restricted delivery and signature confirmation. This means you'll get back the other party's signed signature card to file with the court. That signed card must be attached to and filed with the form called Affidavit of Service by Signature Confirmation. Service is considered effective when the delivery is signed for by the other party. If neither of these options will work or the other party refuses to sign, you'll have to hire a process server. Private process servers must be registered with the state. To find one, you can do a search online or go to the azcourts.gov website for a list. The Maricopa County Sheriff's Office also provides service. They have civil service offices at the downtown and North Phoenix court buildings. If the other party needs to be served in another state, the process server must comply with that state's laws. The process server should return an original or filed affidavit or declaration of service form. But it's important to note that if they give you the original, you must go to the court and file it. Service is considered effective on the date the documents are served to the other party. Now, if the other party lives in another country, service is a little more complicated. In this case, you'll have to serve them under international law. There are special rules for international service. Each country has their own process, and many countries are party to an international treaty. You can find some information on the U.S. State Department's website, and you can see the link and the QR code to that site on the slide. Because serving someone in another country can get very complicated, we recommend that you talk to an attorney for help. Also, you must make reasonable efforts to locate and serve the other party. This includes things like mailing to their last known address, calling them, contacting family, friends, or employers, reaching out on social media, emailing, and texting. If you tried and still can't locate the other party, you can file a motion with the court asking to use an alternative form of service. The forms and instructions for this are in our Step 2 service packet. But remember, you must wait for a judge to grant or deny your motion for alternative service before you try it. If the Arizona Division of Child Support Services is involved in a child support case, you also have to serve a copy on the Attorney General. The Attorney General will then sign an acceptance of service form, but you have to provide the form to them. They have a drop box at the court. The clerk will tell you where the box is when you file. The Attorney General will file a form once they've signed it. Once the other party has been served, you'll have to wait and see if they file a response. Generally, they'll have 20 days to respond if they're served in Arizona and 30 days to respond if they're served outside of Arizona. More time is required if they're served by publication or another alternative service. For example, if they're served by publication in Arizona, they have 50 days to respond from the date of first publication. But if they're served by publication outside of Arizona, they have 60 days from the date of first publication to respond. Some of you are probably wondering what happens if the other party doesn't respond. So, if the other party does not file a response, you can proceed with what's called the default process. The first thing you need to do is complete the application and affidavit for default. This is in the Step 3 default packet. If the other party's default is entered, the next part of the process is the Step 4 default order or judgment. For Step 3, you'll complete the application and affidavit for default form. You must check boxes in each section. If you miss any sections, you'll have to redo this step. If the other party is an active member of the military, you must have a signed and filed Service Members Civil Relief Act waiver. This form is not in the packet, but it is available on our website. On the application, you need to list the respondent's address, or at least their last known address. You must also attach the proof of service, or check the boxes to indicate that the proof is already filed in the court record, and also provide the date and method of service. Proof of service can include the acceptance of service, the affidavit regarding signature confirmation, or the declaration of service. You also need to mail a filed copy of the application and any attachments to the other party the same day that you file it with the court. And in the Step 3 default packet, you can ignore the form called Default Information for Spousal Maintenance. This does not apply to these cases. Step 4 includes a packet for default orders. These are the final orders. You get final default orders by hearing or on motion without a hearing. Default order hearings are held either online or by phone. You must have a hearing if the other party was served by publication, is a minor, or is incompetent. You must also have a hearing if you're asking for an order that is different from your petition, or for amounts greater than requested in the petition. To have a default hearing, you will first need to submit your proposed forms to Family Administration to review. You have to wait at least 10 court days after filing the application for default in Step 3. Once the appropriate amount of time has passed, you can submit your proposed forms by email or by bringing the proposed forms to the Family Department at any Superior Court location. To have a default hearing, you will first need to submit your proposed forms to Family Administration to review. Staff will review your forms to ensure you have everything completed and required to proceed. If delivered in person, they may review the forms while you're there. If they're not able to, or if you email your forms, staff will review them within 3 business days of receipt. After they review your forms, if they're hearing ready, they'll schedule your hearing. If you are not in person, they will call you at your phone number in the court record. If there are issues with your forms, staff will let you know what needs to be fixed. You'll have to fix those issues and resubmit the completed packet. As mentioned, in order to get your default judgment or order by hearing, you must first submit a packet of completed forms to Family Administration. Be sure you filled out the judgment or order correctly. Use your petition to help you fill it out. Your judgment or order cannot be different from your petition. You must also provide a copy of the receipt for payment of the filing fee or the order regarding deferral of waiver of court fees and costs. You'll also complete and turn in the parenting plan, child support worksheet, and child support order. If you're also requesting that child support be withheld from the paying party's paycheck, you must submit a current employer information sheet. You'll also need to provide information to support the child support order. This includes income information like pay stubs for both parties, information about child care expenses, insurance premiums, and special education or medical needs of a child. Lastly, be sure your certification of attendance at the Parent Information Program class is filed in your case. If you want to proceed by motion, which means without a hearing, you must complete the motion and affidavit for default decree without a hearing, which is in the Step 4 packet. Then, fill out and prepare 3 originals of the order or judgment, parenting plan, child support worksheet, and child support order. Next, wait until it's been at least 10 court days after filing for default. When the time is up, file the motion and at least 1 copy of the motion with the court. When all of that's done, prepare a package for the judge that includes 1 filed copy of the motion, 3 sets of the order or judgment and other forms to include 1 original and 2 copies, 1 set of supporting documents, such as the pay stubs, child care, and insurance information, and 2 stamped and addressed envelopes, 1 addressed to you and 1 addressed to the other party. Then, deliver that package to the judge's inbox. Next, the judge reviews the documents. If the documents are okay, the judge will sign, file, and mail copies to you and the other party. But if there are any issues, the judge will reject the package and return it to you with a memo explaining what's wrong. You can then fix those issues and submit the package again, but you'll need to complete and file a new motion. If you keep having issues, we recommend scheduling a hearing where the judge may be able to help in more detail. So, a trial can happen if a response is filed and the parties can't come to an agreement. First, the respondent must give you a copy of their filed response. If neither party has an attorney, the court will have both parties attend an online early resolution conference, or ERC. If they still can't come to an agreement, the court will schedule a hearing. If one or both parties have an attorney, the court will schedule a resolution management conference to try and help both parties come to an agreement or schedule a trial. In both situations, the parties must complete discovery and disclosure. Disclosure is a requirement to voluntarily share information with the other party. Initial disclosure is due no later than 40 days after the filing of the response. Discovery is how you formally request documents, evidence, and information from the other party and any third parties. Discovery also includes depositions and things like interrogatories, requests to produce documents, and subpoenas. A resolution statement is usually due 30 days after initial disclosure, or whenever the judge says. The court will likely schedule court mediation for legal decision-making and parenting time issues, but parties can choose to attend private mediation for any and all issues. If there is no settlement at the resolution conference or mediation, the court will schedule a settlement conference and a pretrial conference. A pretrial statement is required if a pretrial hearing is scheduled. If settlement attempts are not successful, the court will set a trial date for all unresolved issues. The parties can sign a consent order or judgment at any time after filing of the petition. The respondent will have to pay a response or appearance fee. The consent packet is under Step 4, the consent judgment or order. If you come to an agreement, complete the forms in the consent packet. This includes the consent judgment or order, the parenting plan, child support worksheet, and the child support order. It's also important to know that notarized signatures are required, or parties can sign in front of the clerk of court. You'll also need to make 3 copies of these forms so that you have 1 original and 3 copies of each. You must also prepare 2 large pre-stamped envelopes, one addressed to you and one addressed to the other party. Court rules now require that you submit any agreement or consent with a notice of lodging. The filing of the notice of lodging means the court has 21 days to either sign your orders, reject them, or set a hearing. First, fill out the notice of lodging and make at least 1 copy. Then, attach it to the documents you want the court to review and sign. You'll attach to the original notice of lodging 1 copy of each of the following: the proposed consent judgment or order, the parenting plan, the child support worksheet, and the child support order. Next, you'll file the original notice of lodging with attachments. And you'll also file the copy of the notice of lodging without attachments. The clerk will give you back the copy once it's been filed and stamped. When that's finished, prepare a package for the judge which will include the filed copy of the notice of lodging, 1 original and 2 copies of the consent judgment or order, parenting plan, child support worksheet, and child support order. And finally, add the 2 pre-addressed stamped envelopes. When you've collected all of that, deliver the complete packet to Family Court Administration. The judge then reviews it. If anything's missing, they'll reject it and return the package to you with a memo of any issues so you can submit it again. But if everything looks good, they'll sign and return the copies to each party in the envelopes you've provided. Before we wrap up, here are a couple of tips and reminders. Whatever packet or form you're working with, be sure to read through it before you start filling it out. All of the instructions, steps, and procedures, as well as the links, phone numbers, and locations that we discussed today are included in the packets. If you haven't already done so, you can follow the links on the screen to download the forms and our step-by-step guide. Finally, here are some resources that the Law Library Resource Center offers. The Law Library is open Monday through Friday from 8 a.m. to 5 p.m. We're available in person, by phone, by email, and by live chat on our website. The Law Library also offers several services to help you with court forms and court navigation. You can attend an online webinar that features a live question and answer session at the end. Topics include divorce, modification of child support, sealing of criminal records, and more. Appointments for a 15-minute forms review are available. You can ask questions about your court forms or have them reviewed for blanks and missing information. However, to use the service, you must have completed your forms to the best of your ability. The Family Forms Clinic brings Arizona Legal Center attorneys and ASU law students to the Law Library to help you fill out family court forms. And a Lawyers in the Library program offers free 15-minute appointments for legal advice. This service is only available in person, with same-day in-person sign-up. If you're interested in any of these services or events, please visit the Law Library Resource Center events calendar for dates, times, and scheduling information. And while the Law Library can't offer legal advice, there are many free and low-cost options available. Community Legal Services is the local legal aid. You have to qualify based on income, and they only handle family matters when domestic violence is involved. The Free Legal Answers site is only available online. You submit your questions and an attorney will respond. You have to qualify based on your income, however. The Family Lawyers Assistance Project is volunteer attorneys offering free 30-minute appointments by phone to those who qualify based on income. You can use the library's Unbundled Limited Attorney Services list to hire attorneys for piecemeal work. You pay only for the services you need. The Maricopa County Lawyer Referral Service refers you to an attorney for a $50 half-hour appointment. And the State Bar of Arizona Member Services site is a directory of all the attorneys in the state. Please check the description below for links and other resources.